discussions. How long do I have left?
Sir, you have sufficient time. You can continue, sir.
Oh,
you
fantastic.
have sufficient time.
Fantastic. Thank you very much. I've only got a couple more slides. I don't want to impose on Thomas or Attila because they're wonderful speakers and I can't wait to hear them as well. But just talking about regulation in other jurisdictions, as I say, the UK is the one that I know about and it's the one that I'm familiar with. Because I think it's the one that we can use as a lens to look at, because I think we know that as a result of the Outer Space Treaty, states need to authorize, license and supervise space activities within its borders and by its nationals. And again, I want to stress, this is different from the liability requirements under Article 7. Now, one of the things that the UK has been criticised for, I've been quite vocal in my criticism of it myself, is the requirement of unlimited third-party liability insurance before granting the license, because the regulator knows that the state's on the hook for any damage caused. But I can understand why the UK did that. And again, I'm going to come back to one of my key points, that actually, if we're talking about law and if we're talking about regulation, we also need to talk about insurance. Insurance is going to be a crucial element. Get the insurance element right, and all of this falls into place. I also think that as I say there, that we've got a number of jurisdictions, not just the UK, which have regulatory frameworks to try and take account of the shifting contours of space activity. But I think no jurisdiction has legislated for space traffic management. No jurisdiction has imposed a requirement of monitoring the space environment. I genuinely think insurance plus an understanding of the orbital environment in much, much greater detail than we have will empower regulators, and will empower regulators to make brave and bold decisions. I'm not suggesting that regulators become policemen. What I am saying is that we give them as much data as we can so they can make informed decisions. Now, I think one of the problems is we don't have a treaty on space traffic management or space situational awareness, but we do have some understandings and we do have some sort of guidelines exist. Now, I've already talked about the use of soft mechanisms, soft legal mechanisms. And I think there's a number of advantages to developing these. Firstly, they are flexible, they're responsive to ambient changes in technology. And I also think they're not as binding as a treaty, so states are willing to engage in negotiations. I also think, and I haven't put it on here, that a lot of these codes of conduct and treaty, I mean, we look at the Interagency Debris Committee, for example. It's promulgated by specialists, by scientists, not by diplomats. So I think there's an advantage there as well. But of course, we have the disadvantage, as we see with the Space Debris Mitigation Guidelines. There's no legal duty for states to enforce it. There's no compulsion requiring states to perform it. So I think we need to be mindful of the role of the regulator as pivotal. The regulator can incorporate these guidelines into licensing requirements, making them binding, but there has to be a commitment to do that. So I'm going to wrap up now, and thank you so much for listening. And once again, Dr. Kumar and everyone at the Centre, it has been an honour to speak to you. I hope I've given some small insights and some small wisdom for you. My conclusions are this. This is an amazing opportunity for private industry in India to take a world-leading role at the forefront of space activity. I think why I've picked on rendezvous and proximity operations, and why I've picked on, space in-orbit servicing and active debris removal, is because I think these are areas that are really going to benefit from technological research and for development, and I think there is a market there. I do think that national regulators are going to be crucial in empowering that market, though. They've got the international responsibility for authorizing and continuing supervision of space activity. So under Article 6, regulators have to look across at these rendezvous and prox operations, and they have to sign them off. They have to say, we're comfortable with those. And more than that, launching states have international liability if something goes wrong. We know that from Article 7 of the Outer Space Treaty. We also know it from Article 3 of the Liability Convention. They cannot do this. Regulators cannot do this without effectively knowing, having much more information about the space environment. Space situational awareness, space surveillance and tracking. I would think that as a regulator, I would want as much information as possible. Allied to that, I think insurance markets and insurance providers also need to step up and reevaluate the way in which they insure space activity in Earth's orbit. Thank you so much again for listening. I hope that was of some use. I am going to be developing this into a larger paper and hopefully submitting to your great discussions on this as well. If you have any questions,
interesting, sir. Thank you so much.
Thank you so much. I hope that was of some use.
Absolutely. I would now like to introduce our second guest for the session, Dr. Thomas Balcazak. Dr. Balcazak is an adjunct professor at Lazarski University. He is an expert of European Global Navigation Satellite System Agency. Apart from having an extensive teaching career, Dr. Balcazak has also held the esteemed positions of Quality and Safety Director at Flyjet Business, Executive Airline, and Director of Operations at Accountable Manager at Central Wings Airline. Dr. Balcazak will speak on space debris, legal and technological problems. Sir, we're delighted to have you on board with us today. I extend a very warm welcome to you. Kindly take over.
Thank you very much, dear professors, dear organizers. Thank you very much for. It's a pleasure to be here. I would like to also to present you my presentation. So if you give me power to do that, if it would be good. I would like to share my screen. Okay, I have presentation right now. Can you make me presenter?
Yes, so you can present your screen. There's a present now button towards the right corner of the screen.
Okay, I have it. Okay. Do you see my presentation?
Yes, sir.
Yes, sir.
So I would like to continue our discussion, dedicated for space debris, which Professor Newman previously also mentioned. Because I am professor at the university from the, let's say, in legal department, but also as an engineer pilot, I am also expert of European Commission in terms of evaluation of technological evaluation for aviation and space projects. So I have access to modern current technology in terms of space. So I would like to continue discussion in terms of space debris. So as you already knew, currently we have significant launch because of lowered cost of launches for small satellites. We have a lot of small satellites at low orbit. This is like they are like SpaceX, Amazon, and others. And there is some statistics that up to 5% of these launched satellites will be not able to properly dispose themselves at the end of their lives. So due to malfunctions or other problems, they will be not able to use them, and they will remain on their orbits as uncontrolled objects for many years, unfortunately. So these non-functioning satellites remain in valuable orbits for many years with high risk of collision with other objects. And as you can imagine, of course, each collision can generate another collision. So we could have further pollution of the orbit. So we are coming to critical moment, which is that those uncontrolled debris problem is increasing, and we could have situation that we could block all our orbits, complete pollution. So to avoid such catastrophic, let's say, scenario, we have to think about some solution from the legal base, but also from the technological base. On this slide, you should see that some information that space industry is growing, and especially for manufacturing ultra miniature small satellites below 500 kilos. There is a huge growth right now. So we have constellations where there is hundreds of such satellites on altitudes less than 1,000 kilometers. Mainly they are dedicated for some application, dedicated for civilian and but also defense applications. So there is a huge growth. Due to such huge growth, we already had few examples of severe consequences of polluted orbits. This is also a good opportunity for future and even current business. So there is a prediction that until 2034, there will be needed almost 700 missions to remove non-functioning satellites from our orbits. So there is an expectation that this value of this business will be for amount of more than 2 billion euros. There is a growing concern in terms of amount of space objects in especially low Earth orbit. And according to Satellite Industry Association, a report from September 2018, during last 5 years, satellites launched increased in 147% compared to previous 5 years period. So it's huge growth. Also, United Nations Office for Outer Space Affairs and Committee on Peaceful Uses of Outer Space have shown their great concern about this sustainable use of outer space. According to analysis and data provided by European Space Agency, there is a special dedicated European Space Operations Center. Space object in low Earth orbit must be maintained in safe operating scope for not to damage further development space industry. So following on the following slide, I will provide you some data that you will be able to understand the size of this matter. So you see two photos here on this slide, on the left side and on the right side. It shows the simulation on the future low Earth orbit environment in case no additional measures are taking. This is the left photo. So we will continue space business as usual scenario. And on the right side, compared to measures that we will be take and responsive and the responsible legal system and technology to remove those debris. So you see the difference in both, let's say, scenario. In terms of technology, because as I mentioned you, I have fresh access to when I'm evaluating projects from the companies, mainly European, of course, companies that they are applying for grants from European Union. So there is a continuously need to active debris removal missions in the future. And we could have, of course, there is a several technology that we can use. I would like to mention only three, the most, let's say, popular, that the most, let's say, popular within aviation space company here in Europe. So first one is traditional multi-axis gripper. This technology is quite complex because there is several electrical motors and sensors needed. must grip the satellites cramped, and one gripper cannot be used for all, of course, satellites classes. The second technology is based on harpoon. This is high risk of generation of debris when penetrating target. Of course, during this penetration, there is a high risk of creating unintended effects. We can hit other place, other space within our batteries, for example, or some electrical fuel tanks, which can cause even some bigger explosion. And the third one, Mr. Professor Newman also presented this technology on his slide. This is net technology. Disadvantage is that this net technology is not reversible, only loose connection between target and service spacecraft, and risk of collision between them. Coming back to legal base, pursuant to Article 6 of Treaty of Principle of Activities of States in Exploration and Use of Outer Space, including Moon and other celestial bodies, as Professor Newman said, states are responsible for their activities in outer space, regardless of whether it is carried by governmental or non-governmental institutions, persons as well, for ensuring that those activities comply with provisions of this agreement. This provision was further developed also, as you know, in Convention from 1972. And according to Article 2 of this convention, launching states are under absolute obligation to pay compensation for any damage that their launched space object has caused of the surface of the Earth or to an aircraft in flight. But on the other hand, for damage caused elsewhere, the issuing state is liable only where the damage is attributable to its fault or the fault of person for whom is responsible. So we have to prove this fault. Until actually 2020, last year, let's say, Article 2 from this convention from 1972 had practical application into events. First one was from 1978 when former Soviet Union nuclear-powered observation satellite sprayed radioactive debris over large uninhabited area on northwest Canada, and Canada demanded $6 million US in damage from former Soviet Union. Actually, they finalized this in diplomatic way, and they agreed to pay former Soviet Union agreed to pay $3 million. The second event took place a year later in 1979. The remains of US space station Skylab were scattered over Western Australia and the southern Indian Ocean without causing any damage. NASA announced a claim under this convention, but not received any. In terms of Article 3, this convention relating to damage elsewhere, until also last year, there was no practical application. I would say that there was one collision in space, but states parties of this convention did not decide to apply this procedure. The largest collision occurred in February 2009. They activated Russian military telecommunication satellite and operational US telecommunication satellite Iridium collide at altitude almost 800 kilometers above northern Siberia. But because of the speed over 12 kilometers per second, there was full, let's say, destroyed. This equipment was destroyed. Due to similar dangers and international obligations, states require currently private entities to obtain their license for space activities. So it's similar like in aviation for airlines. Also, the other requirement is for insurance to cover possible state liability, as also Mr. Professor Newman said. And in terms of insurance, actually, my friend who is working in UK in insurance company, he mentioned me that they have some offer for insurance for rocket only for 6 seconds. So they cover only their risk for 6 seconds of taking off the rocket. So, but in terms of insurance, we have a few options. The most popular is in the event of material losses, financial losses, property damage, etc., etc. This policies may cover the space object during production, so from the start, before launch, after launch, and also while in the orbit. Second type of insurance is against financial losses, usually covers loss of profits or additional costs that may arise if space objects will suffer material damage. This requirement is already implemented in few countries. Of course, the good example is United States and Great Britain. It should be also noted that the European Union, which is, let's say, owning about, let's say, 19-20% of all active satellites, there was, in 2014, the European Parliament issued decision establishing framework for support space surveillance and tracking. The aim of this system is to plan and implement risk reduction in terms of collision with space debris. So observation of uncontrolled entry of spacecraft or space debris into Earth atmosphere will allow more effectively early warning, thus will reducing possible threat to security of European, in our case, citizens, and reduction possible damage to ground infrastructure. Summarizing, the subject we are calling space debris relates to operative objects remaining in space, such as broken satellites, as I mentioned. According to data from European Space Agency from 2017, there is almost 20,000 objects classified as space debris and they are orbited around our planet. So this amount is more amount of those objects. There is more than satellites, active satellites, working satellites in operations. One of the most important institutions coordinating activities related to space debris is Interagency Space Debris Coordination Committee, which in 2018 brought together 13 space agencies. In September 2017, this committee issued official statement regarding large satellite constellation in low Earth orbit. And this committee drew attention to a number of issues that should be taken into account by satellite producers and operators. So I am going to mention a few of them. So first one, in order to minimize potential risk of collision, this committee recommends that consideration be given to appropriate distance between constellation objects as well between different constellations. The second, also, committee recommends designing satellites in such a way as to increase probability of their removal in the event of failure. So they should have some mechanism, automatic mechanism, to remove themselves from orbit in case of termination, for example, mission or some failure. And there is also recommendation that each satellite should be working no more than 25 years, and then this satellite should be removed from the orbit. Third recommendation is that satellites should be designed in such a way to minimize likelihood of explosion, also to avoid potential collision. So they should have some kind of mechanism, maneuvering mechanism to avoid collision on the orbit. And fourth, let's say, main recommendation is to increase ability to track and monitor objects in the space. And as I mentioned already, within the European Union, we have such operation center that is monitoring. Of course, let's say probability is huge, but not 100% as usual. So far there is no international treaty comprehensively regulating the obligation of space users to avoid production of space debris or to dispose of space debris that already they are generated. According to European Space Agency, government space agency have declared for time being, and this is only declaration, legally not binding, that they will make efforts to clear the most important orbits from the space debris. The problem is, of course, that collecting space debris is mainly due to the fact that that is several times more expensive. So the process of collecting technology is more expensive than sending rockets to orbit. But of course, this is not the changing the fact that the countries that sending given object into space as a rule should be really responsible for its further activity. And regulation of the subject can be also found in this convention from 1972, which actually Poland is also a party. But provision of this convention are intended to protect aggrieved persons. However, due to date of this convention, its provisions are not updated to contemporary realities. And of course, certain archaic nature of this convention in the light of its provision is also problematic to prove damage. As I mentioned, the proof of damage is to prove that the damage was unadoptedly caused by space debris belonging to appropriate owner, appropriate entity. So this is the main problem. And final slide, as we know, space is for everyone. However, legal rules that apply there must necessarily be updated, extended and clarified. It's the well understood interest of all countries that there are ambiguous regulations and actions programs in place to tackle the problems related to the use of space. Thank you for your attention. Thank you very much.
Thank you for the wonderful speech, sir. Before we move on with the presentations, I have a quick announcement for the panelists. You're supposed to mark the forthcoming participants. We have emailed you a mark sheet, so kindly mark them accordingly. All right, so moving forward with the paper presentations, we have Ms. Amrita Gulshan to present the paper titled Contemporary Issues in the Traditional Concepts of Responsibility and Liability in the Age of Space Communication. Ms. Gulshan, kindly introduce yourself before proceeding with the presentation.
A very good evening to all of you and all the delegates present here. Very good evening. Apologies for the poor bandwidth that I am facing right now. There are the bandwidth issues that I'm currently having. Hence why I'm unable to turn on the video. So apologies for that. My topic for this international conference is contemporary issues in traditional concepts of responsibility and liability in the age of commercialization. As we know that the age of space technology is increasing drastically, right? So the attitude from militarization is moving towards commercialization. And this attitude, if we observe on a very close and careful representation on a graph, it would represent that the trend is moving in a very dynamic way, right? The only fear that we have right now, or the space law community would face very soon, is unable to overcome or unable to face the issues that this commercialization is taking place. No doubt it is very important for the sector to commercialize. Yes, it can be equated to the 1991 LPG reforms that we had in trade. Yes, but it is also even more important to face it head on and have a very firm framework for tackling any issue. In my paper, I had explained relating to the traditional principles relating to responsibility and liability. The previous speaker, Professor Thomas, had explained responsibility and liability concept. So I do not want to explain further on that, since it would be just repeating myself. But however, the agreements or the treaties that came into existence and that were adhered to was during the time of militarization, when states took active role in this space sector, right? But today, when the private players are dominating, and we know that I'm sure everybody is aware of Elon Musk launching space constellations, right? Not just private players, even the regional organizations are launching. There is a lot of collaboration and cooperation when it comes to nations in this sector. So when there is such a cooperation amongst the nations, it is very important to move or to slowly graduate from the concept of state responsibility to cooperative responsibility, and to strengthen the principles of responsibility and liability is of utmost importance. In my paper, I had explained Article 6, Article 7 of Outer Space Treaty, which gives an elaborate understanding with respect to this. However, there are plenty of drawbacks with respect to where the state responsibility and liability would go, right? Also, it is a very we have to look at it in a very cautious manner, where the private player responsibility and liability is missing. So that was also explained in the paper. So this was the brief presentation with respect to the paper that I wrote and I humbly submitted. Also, I apologize for the poor bandwidth connection and the network issues. I hope I stuck to the time limit that I was given to. I tried concising it as much as I can. Yes. So.
Thank you for the presentation, Ms. Gulshan.
Thank you. Thank you.
You may put forth any questions you have to the panel for the next 10 minutes.
Yes, I have one question. See, as all we are like discussing about the privatization of space sector in India. My specific question is like the since we don't have national legislation, then how we should be ensuring the liability aspect because as per the liability convention or the outer space like the regime, it is the state who can be liable and internationally, but not the private like the private entities or the individual or the company. That is one aspect. The secondly, like the if like the private companies entities, if they are like the violating like the sovereignty of the other states, also damaging which is caused by the private entities like the space object in space. Thirdly, what would be the like the their liability when they are causing damage on earth's surface? So like the what is opinion of the here the scholars how India should be proceeding, whether like the it should be following the like the US model or whether it should be following the UK model. What like the what are the so what is the what are the suggestions like how India should be proceeding?
If I may start, I think the first thing is to identify the types of activity that's going to be undertaken. I think what the UK has done is it's looked at where it wants to go, and the legislation has followed that model. So what we've effectively got with the Space Industry Act 2018 is we've got a licensing and planning regime, which is exactly what you need if you're going to build launch sites. You need to plan the launch site. You need to check to make sure the health and safety aspects are there. So that's the first thing. Think about the type of activity that's going to happen. Second, I would suggest that there needs to what we see in a number of jurisdictions, and I think we've seen it recently in the US with SpaceX and the FAA. We need to try and get away from the regulator as being seen somehow in competition with the private industry. The regulator needs to be seen almost as a body that empowers private industry. So I would really try and establish a collaborative model whereby industry, the public sector and the regulator all work together. I think absolutely you need national legislation to do that. I think national legislation and licensing schemes are the way forward, because that then gives the regulator teeth. It gives the regulator the ability to say, okay, the debris mitigation guidelines are non-binding, but you're not going into space if you don't follow them. So I think that's where we can get the enforcement, because I don't foresee a treaty on space debris. I don't foresee a treaty on anything happening in the near future. Treaties take time. Treaties are, they're creatures of compromise. So what I think we'll have to see is the regulators are going to become the focal point. A good statute will empower the regulator, will make the regulator a collaborator with industry, and it will ensure that insurance, debris factors all feed into that. So that's sort of some thoughts for you.
Actually, before like the I would I would like to give one example like the that has been not like the gone into the accident. However, like when we are recalling this Antariksh like the Devas deal, which was very problematic. In that particular situation, a satellite was launched by the ISRO, and that was used by the Devas Multimedia. Let's suppose if Devas Multimedia is encroaching sovereignty, because India has the border tension with the one side China, another side with the Pakistan. In that particular case, what if if there is no the regulation? What if in even case, see, there can be a condition situation, even if regulation is there, even the monitoring is there, even if by any chance, if the private player, they are sensing something into the another side of the border, that is clearly violation of sovereignty of the other state. How that should be dealt? My question is how that should be dealt. Because see, in case of the even monitoring, because private entities, they will work for their own interest. They the current situation, we are saying that these multinational companies, and there are the multinational companies, they are not bothered about the state or the small states. They are bothered about their own the benefits. So how we are going to deal with those situations? How we are this space regime or the national legislation should be they're tackling this problem. And this situation can be happen into the any other country, like the Australia or the Europe. Anyway, like the Europe and Australia, there is no hostility near the border, but with India location there, that is the situation.
I mean, I think you're right. I think the problem you get with more and more private companies becoming involved is, as you rightly say, private companies, they don't care about states, they don't care about boundaries, they care about one thing, they care about money. And that's where I think that's where the balance is going to change, because the Outer Space Treaty regime is predicated on states being able to control these companies. Now, we've already seen with SpaceX, that's not necessarily the case. States can't always control their companies, and they don't always want to. They're quite happy for these companies to make money. That has, as you rightly point out, security implications, big security implications. And this is where we move out of space law, I think, and into diplomacy and into international relations and how states should behave in regulation of their private companies. I don't think the space if I can be honest with you, Dr. Kumar, I don't think the space industry has that level of maturity yet. I think we're at the stage very much where we're still looking to the state to hold the reins. But I think there's going to come a point where the state isn't going to be able to. You get a big company, a Google, an Apple, they're not going to care what the state does. They'll take a fine. The state can fine them because they can swallow it up quite easily. So absolutely right. I think that's an area of development that needs to be looked at. I think in terms of sovereign disputes where private companies encroach on sovereignty, I think there needs to be an effective international dispute resolution mechanism as well. So you're right. There are lots of questions in this area and lots of holes where I think the space industry and space law is just not mature enough yet.
I would like to add that I see some similarity because we said already that the space market is during big transformation. So I would compare it to aviation market, I don't know, 20 years, 30 years ago, when we had mainly only airlines that belonging to governments, countries. After the commercialization, what we have current situation. So I would say and agree that what Mr. Professor Newman said, that one thing is in terms of this market is to control it by civil space authorities and all procedures, regulations. But the other thing is to use the commercial side, which is based, for example, on appropriate insurance, because current market aviation is based on those two things. One thing is, of course, they have to fulfill legal procedures to have license. Actually, the license is divided into two sectors. One is commercial license and the second is operational license. In terms of commercial license, you have to prove that you have enough financial support to provide safety operations, and operating side, which is most dedicated for technical issue safety, but from the technical point of view. So we could have similar situation in terms of space commercialization, that licensing will be one thing, concession will be another thing, and of course we can use this insurance policy, insurance market, because as I see insurance companies, they are also more and more deeply involved in terms of knowledge, of space market. So as I mentioned during my presentation, I have one of my friends is working for one of the big insurance company in UK, and he said that they have some offer that they can make a policy for and covering only 6 seconds of taking off the rocket during the rocket taking off. So, and they have also some requirements for operator, that they also can say that, okay, when you will implement such scenario in terms of such technology, such experience, we can cover your operations by our policy. If not, then I'm sorry, we are not able to cover your risk. So this is also very important. I remember, because I was involved in a few startups at airlines. So I was going for some presentation in front of insurance company to London, actually. And we had to prove that we have, of course, enough knowledge, enough experts that they will be working in our organization. Also financial support. So we have to provide some proof, and they will, based on that, they decided if to cover our operations or not. So one more time, a legal base based on licensing, certification from civil space authorities, and the second one, commercialization part, which is taken from insurance policy, etc., etc. Thank you.
If I can also add, I think another thing that I agree with Thomas entirely. I think that's exactly the way to go. I also think another thing we're going to need to consider is spectrum. A lot of these, the way we're looking is really hungry on the RF spectrum, and I think the ITU is going to have a job as well, looking and seeing how that's regulated. So absolutely agree with Professor Thomas.
There's a question for the panel in the chat box. What is the feasibility of satellite propulsion systems in mitigating space debris? How helpful are they?
If I may further, elaborate the question. This is Lakshay, by the way. So recently, a French startup developed an iodine-based electric propulsion system, and that was tested on board a Chinese satellite launch vehicle. So this apparently can be a breakthrough in satellite propulsion systems, because it is much cheaper and it has the ability to change the satellite's orbit. So this will ensure that the satellite and the LEO is spending less time, and therefore is re-entering the Earth's surface, therefore reducing the space debris. So according to you, how feasible is this? And is it likely to take off as a concept?
One of the things I do know, I'll bow to Professor Thomas's engineering experience, but one of the things I do know as a regulator is that there are certain orbits now that certain regulators will not allow satellites to be inserted into unless they have propulsion. So one of the regulatory requirements that regulators will impose on a mission is if the satellite doesn't have a propulsion system, or if it doesn't have its ability to change its orbit or to conduct collision avoidance, then it won't be given its license. So I think having propulsion and having cheaper propulsion enables, you know, mission operators to be able to do this. So I think that's got to be a good thing. I also think with the rise of larger constellations and mega constellations, and also with on-orbit servicing, having satellites that have this propulsive capability will make it easier for the regulators to approve the mission. So from a regulatory standpoint, I would think absolutely. From a financial standpoint, it's still going to be whether the numbers work, because that's what, going back to Dr. Kumar's point, that's what's going to make this work. If the money works right, then it'll benefit. If it isn't, then it won't.
Thank you, sir.
Yes, in terms of propulsion, propulsion for rockets that you could be used, as I mentioned, within currently when I am evaluating kind of technology, we have to be based on this agency space, the BRICS Coordination Committee decision from 2018, and we are, let's say, this is the base for us. So we are controlling is if the technology, propulsion technology, is safety enough to control, let's say, 100% of the work. So there should be added mechanism to emergency mechanism that satellite could be able to maneuver to avoid any collision in the Earth. This is the obligation right now for startups in terms of their propulsion system to have such emergency system included in the controlling system of propulsion. The other is, of course, emergency system that will be also able to remove satellite from appropriate space in emergency situation as well. So from the technology point of view, companies, they have to prove that they have such system implemented in their propulsion system. So we are evaluating currently based on this statement from 2018, every technology, especially propulsion system.
Sir, there's a follow-up question in the chat box. Is it only possible for spacefaring states? How about underdeveloped states? How can they be assisted in accessing and utilizing space resources?
I think this is an area that really needs developing. I think it needs developing on a number of levels. Firstly, on the international level, the discussions that occur at UN COPUOS, the United Nations Committee on the Peaceful Uses of Outer Space, I think they need to broaden out and be be more inclusive. And I also think that the states that don't have space capability need to feel ownership as well. I think they need to feel ownership of the orbital environment, because without that, they will let the conversation drift on to those who do. So I think part of it is empowering states at a national level and an international level to do this. I think also there are memorandum of understanding, these quasi-treaty arrangements whereby relationships between individual states, bilateral relationships with individual states, can encourage technology development. And I think this is the way in which, circling back around to all our concerns about space debris, we can encourage and incentivize new space actors to behave in a responsible way, with technology incentives, with tracking incentives, with sharing capabilities such as launch. So I think in terms of developing states and developing those states that don't have access to space, I think there's a lot of work to be done, but I think it's quite low-hanging fruit. I think it could be done relatively easily. So I think the benefits of space are clear. I think the benefits of taking part in space activities are clear as well. And I think all states should be encouraged to claim ownership of the orbital environment, because I think very, very quickly it can become a monopoly if we're not careful.
There's another question. How can space be used for social welfare?
I think we see a number of applications of space technology for benefiting society. I mean, on a fundamental level, getting infrastructure in place to places that wouldn't necessarily have infrastructure. There's a term I've heard called digital poverty, and that means that places that don't have access to the internet, don't have access to communications. So I think that in one sense, providing information and providing access to data and, our mobile telephones and providing internet, I think that of itself does that, because that then unlocks the education abilities. That then allows people to access information and allows people to become aware of, the benefits of space. Now, speaking specifically, obviously, disaster relief. I think disaster relief is used, satellites are used quite considerably for that. I also think that Earth observation can detect changes in climate. So I think there's a number of ways in which they can help society, and really we should be promoting these benefits of space.
There's a question by Arunab. Has space debris killed anyone?
Maybe I will answer this question. So far, not. During my presentation, I presented some photos, real photos, from the crash of debris with International Space Station, and this is something that, let's say, from the safety point of view, we should implement already some action against such possibility to minimize the risk. We already have in the near future some scenario that they might be such situation that somebody would be killed because of, for example, dehermetization of space, which is possible. And there was already few examples of crashes of space debris with rockets, with some equipment. Not yet, and this is good that not up now nobody was hit. But we have to think, and we have to avoid such situation and implement action right now.
We've received another question. How do unmanned spacecrafts protect themselves against space debris?
Yeah, maybe this is also some technological question. I would. This is similar to those technology that should be implemented in terms of propulsion system. In terms of unmanned spacecraft, they should have appropriate numbers and system of sensors that would be able to be active all the time and would be able to avoid crashes with other spacecraft. So it's something like in aviation, we are saying that we have TCAS system in aircraft. So the same, let's say, similar system should be already implemented in spacecrafts, and is already, this system is one of the basic system that is right now one of the requirement, basic requirement. Sensors plus propulsion system that could be activated in emergency case to generation any risk in the space, to avoid crash in the space, any collision in the space.
Do any of the participants have any further questions? All right, if no one has any further questions, this will be session 2. There's a new question. What about future of suborbital activities? How far do they overlap with aviation law?
Thomas, as an aviation expert, I will bow to you on this. I have some thoughts, but I'll bow to your expertise, sir.
Well, it's in terms of suborbital activities. This is something between space activity and aviation activity. So I would say that because currently we have the situation that some countries already implemented some regularities in terms of suborbital activities. I would say that currently those regulations, they are more similar to aviation regulations than to space regulations, because aircraft is taking off from the ground and landing on the ground finally. The only thing is that there is some part of his flight that he's within the space. So I would say that currently this regulation depends on the countries. Mainly the most involved countries, they are the countries that they have such suborbital activities already in place, like United States, for example. But I would say in general that they are mostly similar, that they are extended, those regularities, this is the regularities that they are extended from aviation regularities. Also in terms of technical, in terms of aviation systems, etc., because we have already some technology that, for example, aircraft that we are using for traveling also is able to have like 15 kilometers height of flight, and we can be already in some part in the space. So I would say that in general this is the aviation regularity mostly.
I think just
yeah, sorry for that. Just to add a few information with this regard. As I am aviation lawyer mainly, and in 2005, nearly 60 years ago, the representative of India presented a paper to the ICAO Council about the suborbital activities and flights. And so ICAO started to think and work about this issue on a regulatory way, and the UN Corpus is also highlighted this issue pretty well. The International Law Association Space Law Committee also put on the table international regulations. I mean, of course, the draft of the new international regulation in terms of this issue, because it's getting more and more more and more part of our life, and that's why it is very up-to-date question in history. Thank you very much.
And yeah, if I can just sort of add, the UK has looked at this. We've introduced the Space Industry Act 2018 because we're looking to develop this as an industry. We're looking to develop suborbital activities as part of our industry. Now, of course, two things need saying. First of all, there's no definition in international law of where space actually begins. We have, we have an understanding that it's the Kármán line, but that's a bit fuzzy. And actually what we have are states now saying where they think aviation stops and where outer space activity begins. So it's kind of very much an arbitrary line that states will draw and say, right, okay, at 80 kilometers, at 100 kilometers, 120 kilometers, we're going to stop aviation law and we're going to start outer space law. So I think that a number of things that we have an issue with are, as Thomas rightly said, it's those hybrid craft that behave like aircraft, then go into outer space, then come back. The Virgin Galactic, perfect example. They only spend about 6 minutes in outer space. So we talk about space tourism, but actually the majority of it is spent in air, in air law. So I think this is absolutely right. And I think what we're going to see as states recognizing this zone and this being, passing to the regulator of the aviation law in the UK. Now it's the Civil Aviation Authority that regulates suborbital flights. So I think that both Attila and Thomas have alluded to that. I think that's very much the model we'll see states go down.
Sorry. Sorry.
No, Attila, go ahead, please. Go ahead.
No, just the financial issue as well, not on the legal issue. So if I pay $100,000 for a trip, I would like to go home to my wife and to tell her I was in outer space, I am kind of astronaut. So it has to be somehow solved legally as well, because it's necessary because of the business.
Okay, so if I have to address this question, probably I should say that this is the first question which has cropped up when the space activity started in 1957, because we wanted to delineated the outer space from the airspace primarily for the purpose of understanding which law should be applicable. Should it be aviation law at a particular altitude, or should it be space law? And there has been a debate in the UN Corpus for a long period of time with respect to this demarcation of the outer space. And unfortunately, no adequate criteria has been found even till today. Especially because this is actually a kind of a unnatural distinction which we are trying to draw between the airspace and outer space, as there is no natural distinction. There is no natural distinction because as you move upwards, only thing is that the density of the atmosphere would reduce down. That's it. Outer space is not the void per se. Density of the atmosphere reduces down. So, we, for the purpose of application of the law, are trying to make a distinction between the airspace and outer space, and that is the reason why the international community could not find a proper solution with respect to this. And more significantly, as the technology is developing, aviation activities are moving to the higher level, and the space activities are coming to the lower orbits. The orbits are coming down. So obviously, we are going to have an area wherein both the aviation and space activities are going to take together in the same zone. So therefore, this has become more problematic issue at present. As rightly pointed out, the suborbital space tourism would definitely pose more challenges. Should there be actually application of aviation law, or should there be a space law? But as of now, we have the understanding at the international level that it has to be decided on case-by-case basis. UN Corpus has basically, the states have agreed in the UN Corpus level that actually the concerned competent authority has to look from the case-by-case basis. They may have to take into consideration the altitude wherein the activity has taken place. They may have to take into consideration the kind of activities in which the people are involved in, nature of the object. So all those different factors, after considering that, one has to decide whether it is aviation law which has to be made applicable, or is it the that's how is the current scenario. Maybe until some high-grade law comes into picture for dealing with all these things. So we are not very sure about how does it go forward in the.
There's one last question before we wrap up. We know that space debris is quite dangerous. Will we ever have a news-related sector specifically devoted to it in the near future?
Yes,
I think we already have it.
As I mentioned, there is like 20,000 space objects that we can treat them as a space debris. And the problem from the technology point of view is that I mentioned about few examples of technology like net, like Harpoon, like some gripper, etc., etc. The problem is that we should find a solution that based on which we will be able to collect those debris without generating additional problem in generating additional debris. And currently, frankly speaking, we are using very, let's say, not very sophisticated technology that we can, let's say, have imagination of using simple net, simple harpoon. This is very, let's say, very not very complicated technology, and up to now there is no let's say perfect technology how to collect it, how to avoid additional risk, and taking into consideration, of course, low cost technology, because as I mentioned also, the problem is that collecting space debris is few times more expensive than sending those rockets with satellites in the space. So finally, we have to find the solution that will be commercial, from the commercial point of view, acceptable, but also safety for the space usage.
Thank you, sir. So I think that will be a wrap for this session. Thank you very much, Dr. Bolzak, Dr. Newman, for being here and giving us your invaluable insight.
It has been my honor. Thank you so much for all the great questions and the great interactions and some brilliant presentations. Thank you.
Thank you so much, Dr. Sipos and Dr. Bhatt, for your input as well.
Thank you.
Thank you very much.
So we will be starting our third session within 10 minutes, sir, with the same link and the same place, sir.
Okay.
We have our third session, so we are starting. And yes, Balakista Reddy sir is there. Good afternoon, sir.
Good afternoon, sir. Good afternoon. Can you hear me?
Yes, sir. Yes, sir. Yes, sir.
Okay.
Now, sir, since sir is there, so we can start our third session.
Now or after break? Hi. How are you, Krishna? Now or after break? When should I join?
Sir, it's up to you, sir.
Okay. Maybe I'll finish. I just finished my other meeting, so I'm sorry I'm joining late. Okay. So maybe I'll talk about that. So
yes.
Good afternoon, friends. Sorry for delay. So I'm going to speak few minutes. Of course, already some of my colleagues touched issues which I'm going to, but I'll talk about the COVID pandemic and what is the impact of that on the space industry particularly. So before first part, I'll speak about what is the technology law. We all know that space technology, one of the significant achievement of man in the 20th century was his ability to leave this planet and have a complete view from outer space. Of course, this was imagination for centuries, but it got realized only on 4th October 1957. And friends, we have seen last six decades, so much development happened all these 6 decades, particularly though it was scientists predicted, but this became reality. After this 4th October, we have seen Yuri Gagarin was the first man in space and Neil Armstrong. And today we are talking about space stations, space hotels, buying and selling of flats in outer space, all this. Okay, these are all science, but what we have to do with the law? So what we always say that law follows technology. It is true with the space. On the 4th October, things happened. 14th November, exactly 40th day, the United Nations came out with resolution urging international community to use space for the benefit of mankind. That is where the law started, and today we have well set law or international space law. Question comes, why space law we required? If we don't have a space law, can't we? Yes, we required because the use of technology for betterment of mankind, protection of IP, then maximum utilization. If you don't have a law, it create lot of present and also future conflicts. These kind of issues we need law. Of course, international space law is body of law, regulates the use of outer space, and we have seen how it developed last 6 decades. Because initially it was from 1957 to 63 soft law phase. Various UN General Assembly resolutions came. Soft law, non-binding in nature. Then second phase, important phase, and today, of course, that is very much required for debate. Hard law. There are 5 important treaties, including Outer Space Treaty 67, then liability Outer Space Treaty Registration Convention, then we Rescue Agreement and Moon Agreement. All these 5 important treaties, what we call important phase or hard law phase. Again, now we have a soft law, direct DBS principles, remote sensing principles. All these, of course, you have done, but just cursory thing. These principles, whether it's a hard or soft, we have developed very many important fundamental principles for governance of space, particularly principles like equality, free exploration and use outer space, non-discrimination, non-appropriation principle, not to place nuclear weapons near Earth orbit, moon and other celestial bodies are used for peaceful purposes, astronauts are the man invoice. All these important principles which we developed part of the both 1967 onwards. But how far these principles are again relevant present context is a question mark, because most of these treaty regime which developed when space industry was predominantly, it was a government driven thing. Okay, it was public sector dominating sector, but things have changed in the 80s and 90s. So is the existing international space law relevant in the context of commercialization, privatization, whatever, deregulation, all these things? That's the question. And important review for this is the Outer Space Treaty 67. You all know that corpus of space law is developed only based on the Outer Space Treaty 67. But Article 6, Article 7, particularly Article 6 is today, lot of debate is going on that, space activities carried out by whether, governmental or non-governmental, liability issues. All those things are again, now debatable issues in the present context, and we are again debating. Recent, particularly last 20-30 years of development, if you look at, we have seen globalization, its impact on globalization in general, and particularly how it has impacted the space industry, particularly satellites and other things, especially. Then commercialization. Now we are phase of privatization, where lot of issues which are prompting us, for example, security versus commercial. How are we going to do about this? Whether security or is it we are going to compromise part of the commercial activities in the name of security? Privacy versus commercial, private versus government. These are the issues which I am just raising. Of course, you are debating, but this is a thing which we have to look at in the current scenario when we are talking about the private participation in big way in the space industry. Particularly today, we are in a changed scenario. So space activity shifted from government to private. Commercial space activities are replacing by government things. Lot of concerns we are raising, actually, utilization of these things, particularly national and international context. Increased capabilities of use of space, number of ways. So how are we going to cope up with this is the challenge today which is posing, and where the exactly space law come into picture. Indian context, particularly, these are all things which develop part of the international space law. But India, if you look at, India is going to play a major role in the Committee of Nations in the coming years relating to space industry. So Indians, emerging a serious player. There is no doubt, though we have a limited resources, whatever we are doing. But important issues relating to that is safety, authorization agreements, dispute resolution mechanisms, law of contracts, transfer of property, stamps. These are the issues which we don't have adequate thing, and particularly because of lack of I can say domestic legislation, of course, Professor, but others also spoke. Though, friends, I am happy to share with you all that the Act for Space Legislation, need for space legislation, I did 30 years back when I was a student in JNU. First, my article in 1996 I wrote, where I highlighted the need. You can refer my article, need for space law. Why India needs space law? Because India is doing commercialization, privatization. India is doing million, or I can say billion business dollar. So there I urged that we need space law. Of course, 1996 first article where I narrated that why we need, how we need. I studied some of the existing legislations of that time actually, and then I proposed. And today I'm happy to share that most of the research which I initiated 30 years back, it is happening with my lot of young students and all. So why it's happening is again, commercialization, privatization, particularly even government side also ISRO created, then Antrix Corporation, all this. So today that is the stage we reached, in India. So this is background about that. Coming to the pandemic, actually, friends, you know that the global legal order, it is not only confined to space, but global legal order is going to be changed. Is it that global legal order pre and post pandemic? Pre-pandemic, we have institutions created. We are doing all last 60-70 years of international governance, but things are going to change. So particularly what I use the word is COVIDization. So COVID pandemic, we say COVIDization is going to impact the global governance in general and the space sector in particularly. If that is so, how are we going to look at that? The inspiration for this COVIDization and COVID pandemic I'm talking about is part of globalization. Friends, you know the globalization which has impacted global society for almost 6 decades. When I say globalization, liberalization, these things. So it has positives, negatives. Globalization has solved global problems, and of course there were negatives also, particularly developing countries were sufferers, all these things. But similar analogy we can draw for space industry or other industry also. So that context actually, COVID pandemic. Today, forced last 1 year or precisely 10 months, how things are happening. I'm talking about general, and I'll link that to space. Pandemic has forced states to close borders. Quarantine were imposed. Travel bans, paralyzed supply chains, export-import restrictions. All these now posing fundamental questions in the governance, particularly the impact of COVID, fundamental international governance questions. How will the pandemic influence international legal order in future, including space legal order? How the pandemic might reshape world order, including aspects for international cooperation? Can the pandemic, will accelerate USA decline, because already that some of the states, including European Union, so-called countries like America, failed states. So how this pandemic is going to look at that? So far, what we are following, cooperation in general governance and including the space sector, and India, borrowed a lot of cooperation. Is it that cooperation is going to continue after post pandemic? When non-solidarity, normalization, these are the things which we have to analyze in the context of general international relations and international order. Space is not one which we should not look at in isolation. So the impact, if you look at caused pandemic in general, all industries, I said a lot of things are happening last 10 months. For example, postponement of launch schedules, stopping of all the activities relating to the space industry, particularly. COVID actually swept out world industries trying to look at all the governmental business activities. Some launches are moving delayed, some are happening. These last 10 months, this is happening, particularly launch rockets continue to be launched, but however, a lot of rockets are stopped. For example, I can say suspending launching of the time by very many countries like Europe and other parts of the world. Manufacturing, then testing, then particularly this is not only confined to the developing countries like India. Particularly if you look at OECD countries, European countries, small countries, of course, they are major sufferers because of COVID impact on the space industry. OECD crisis, European. So India, if you look at India, of course, we all know that part of Atmanirbhar initiatives are self-reliant India. So Indian private sector, component in the so-called Atmanirbhar made by the finance minister, 20 lakh package all. So there were 8 sectors, but one of the important sector which part of the Atmanirbhar or self-reliant was outer space. Outer space has been identified one of the 8 areas where major reforms which we brought, the part of the COVID. Particularly Finance Minister Nirmala Sitharaman announced a greater role of private sector in India space program, including launch vehicles, satellite manufacturing, space-based services. So Minister also acknowledged the work done by private sector in the development of Indian space technology, space capabilities. So these are some of the things we have to carry forward. Particularly the announcement, government said that it will create private sector, it will create fund for benefit of private sector. So these are some of the initiatives which was made by part of the Atmanirbhar, and of course, lot of initiatives. Last 8 months, I can say that India has initiated towards the private participation, particularly ISRO-led group, private, and also there are today, if you look at 60% of ISRO budget is spent to private space industry. So this is where the space industry, of course, it has to go a long way. Particularly, we have to keep one important thing. Other speakers spoke, so I don't want, but space activities bill. I mentioned, friends, though this is a one area where we need to have. So it is a need to consolidate whatever I spoke or speaking about that. To consolidate, India needs to have a space legislation. So I mentioned, friends, the last 30 years, things are happening, but it's not moving in the proper direction, though, it is a, but I think it is a time for India, whatever, whether it's a pandemic or, post-pandemic, try to consolidate. If we had to consolidate space industry, I think, there is a need for, space activities bill 2017 has to pass, and in that direction, last 2 years, some of the work is, happening through as a part of the ISRO and outside ISRO. But I think it is a time for us, or in India, to consolidate, to continue the process which we initiated only through having a important legislation, particularly the agency we are talking about, the in space and the other areas. So with this, I thought, I'm only raising these questions, but we can, discuss further course of time. But this is going to be the scenario post-pandemic. It was a pre-pandemic, but it is also post-pandemic. With this, of course, I'll take up some questions or something, but my idea is to just intervene that how things have happened, how things are going to happen post-pandemic. Thank you, friends. Thank you. Okay.
Yes, sir.
Thank you, sir. Thank you, sir. Like you have given your precious time to us. Thank you, sir.
Okay.
Thank you so much for a wonderful presentation. I must disappear, but that was really great. Thank you so much.
Thank you, sir. Thank you.
The session will now be continued by certain presentations. The first presentation will be done by Dr. Sheikh Nizam Ahmad Shafi on public-private partnership in the development of space infrastructure in India and international perspective. Sir, if you could please give a brief introduction about yourself and then continue with the presentation.
Can you give me the link so that I can show my PPT? Hello, Shailendra.
Yes, sir. You can share your PPT.
So there's an option to present your PPT below, sir.
Which side? Present or now? That one?
Yes, sir.
Shafi sir, you can go to the present now, click on the tab and then open your PPT from your desktop. Choose your entire screen. That would be benefit to you, sir.
Yeah, Rahul.
Yes, sir.
Yeah. Good afternoon.
Good afternoon, sir.
Yeah. Can you please guide me, dear?
Yeah, you just go to the present now. Have you clicked on that particular tab, which is on the bottom right side corner?
Right side corner, present now is there, okay.
Yes, and once you click on the present now, there are three options. The first topmost option is your entire screen.
Full screen is there.
Yeah, so just click on that and then from your desktop or laptop, just select that particular PPT presentation which you would like to show us.
I'm not getting here. Report.
Yeah, I think you are going to see just our screen, which is on the Google Meet. Just click on the share and then automatically you can.
There's no share here. There's no share here. See.
Now click on that window. Click on that window. Click on that particular window. Then the share button will be enabled. Just click on that particular screen, which will turn into a blue box, and then the share button will be enabled.
No, just wait. Now see, I clicked those three dots. Okay,
Yes.
I change layout full screen.
No. Don't go on the three dot. Just before three dots, there is a presentation now tab.
Yeah.
Click on that.
Okay.
And then go to the first option. Entire screen.
Click the tab.
Yes, entire screen is the option which you need to select. And then there will be new window that will be popping up. There you will be seeing our present meeting screen. Select that screen. So bottom share button will be automatically enabled.
It is not coming here.
See, I'm just showing you how it will be there.
No.
Are you people able to see my PPT?
Yeah.
So like that way it can go ahead, sir.
But here I am unable to. Okay, no issue at all. Let me.
Sir, if you have sent your PPT to the center's email ID, we can help you in presenting the PPT, sir.
Okay.
Shailendra, if possible, can we move with the next presentation? Meanwhile, Shafi sir can send you PPT so that we can save time.
Yeah. I sent it.
Yeah, okay.
I surprised.
Yes, sir. Thank you.
Okay, Shailendra, are you able to hear?
I think now voice is clear, yeah.
So we can hear you, Shafi sir.
Hello.
Yes, sir, we are able to hear you.
Hello.
Quiet.
Hello.
Yes, sir.
You're not audible.
Sir, can you check again? I don't think there should be any issues now.
I sent a mail. I sent the PPTs to this mail.
Sure, sir. We'll share the screen.
Yeah.
Shafi sir, we are able to see your Yahoo Mail. So if possible, you can switch the screen tab.
Yes, sir. You seem to have started presenting the screen.
So you need to just switch your screen tab and go to the presentation.
You can just click on the presentation and start presenting, sir. You
Okay,
can
I'll do
just
one
open
thing.
the PPT.
Okay, without PPTs, I can go ahead. There's no issue at all, I hope. Okay. So anyhow, I hope you are able to receive my voice. Is it audible?
Yes.
Yeah.
Sir, your voice is audible, your screen also visible. So your screen is a mail. You can open your PPT and we can see your PPT.
Yeah,
In your computer, you can just open your PPT, we can see it. Yeah.
Yeah, I opened here.
Then it should come to visible. Now, still your email account is opening. Your mailbox is open now.
Okay, sir, no issue. I will without.
Then sir, you stop sharing because your screen is visible, sir. Then only our student, our team can share your, yeah. Okay, this fine, sir. Yes, sir. Yes, sir. Yes, sir.
So my PPT is visible?
Not now. Now you have stopped your sharing, but maybe our team member can do this sharing thing.
Okay,
Sir,
okay.
could you please resend the PPT? We have not received it.
Okay, okay, okay. Extremely sorry for this. Yeah, I sent, sir. I sent.
We haven't received it yet, sir.
I sent already, dear. I sent. I sent. Yeah, please check it. I sent it. See, check it. Have you got it?
Sir, could you just check if it is the same email ID? It is casml@slsh.edu.in.
Let us casml@slsh.edu.in. Yeah.
Yes, sir.
Yeah, I sent it. So please check it.
We have not received it. Probably we'll receive it in another 2 minutes. I think you can begin with your presentation if that's all.
Yeah, yeah, please. I will do it. Okay, shall I start now?
Yes, sir.
Yeah, is it audible now?
Yes, sir.
Yeah. Okay, good afternoon to one and all. First of all, I regret for the inconvenience caused to you all because it is a technology aspect. Okay, anyhow, let me thank Professor Sarfraz Ahmad Khan and also Shailendra sir. At the same time, the various luminaries in relation to the space law, aviation law, and also various participants for today in relation to this particular one-day international seminar on privatization of space sector in India, issues and challenges. So my topic for presentation is public-private partnership in the development of space infrastructure in India, an international perspective. Now, really, actually, since morning I was hearing and it was a wonderful presentation by each and everyone where they have spoken about the fruit, where they have spoken about the fruit, means what in the space, what you are going to do, exploration, exploitation, at the same time mining, tourism, medical research, and also precious metals you want to bring from there for research purposes. Everything is good. It was in relation to the fruit, where all the participants have discussed very well and wonderful. But I am going to discuss about the root now. The root is the infrastructure. Very recently, Honorable Finance Minister Nirmala Sitharaman, during her budget session, she has stated that future projects for planetary exploration and outer space travel will be open for the private sector. It's good. Making statements is very easy, but do we have many things to add so as to go there into space to explore, as Professor Bhatt sir has stated? So now, when this is the thing here, the root is in relation to the development of the space infrastructure. Unless until there is an infrastructure, well-developed infrastructure, we cannot go into the orbit, nor we can do any explorations. There must be a robust, there must be a strong infrastructure at the root level so that you can get the fruit at a later level. So now in this, what my research paper explores, it explores three things. Number one, explores reasons why public sector space stakeholders want to pursue a PPP model for delivering services, infrastructure, and innovation. This word infrastructure relates to the technological commercialization, number one, and number two, commercialization and commercial development here. So technological commercialization and commercial development, both the things are included under the word infrastructure. And number two, it proposes a phased approach for strategizing, planning, and implementing PPP delivery models along with guiding principles of neutrality, transparency, accountability, and governance. So here when you are speaking about the PPP delivery models, at the international level, we are having 19 international models. I'll give an example like BOOT, B-O-O-T, that is build, own, operate, and transfer. And this is a type of transaction known as CIC, Complex International Contracts, where is a project of minimum 5 to 10 years. So there is a phased approach for strategizing this type of PPP to be taken into consideration in the development of this space infrastructure. And number three is examining the case studies, including successful or unsuccessful PPP models, offering lessons. Today we are going straight away into the PPP. Now, what are the lessons learned by the US? What were the lessons learned by the EU in relation to bringing this PPP model by which they went into the development, whether they were successful or unsuccessful? At later level, I will discuss here. So now, the next question here is, what is a public-private partnership? The word public denotes that the government or the government agency, and the word private denotes a private investor, maybe a domestic investor, maybe a foreign investor. So because today government is unable to bring out these projects independently, it requires hand, because in 1990s, an initiative has taken place in relation to the liberalization, privatization, and globalization, where India is not at all an exception to this concept. So now we have to explore by which we have entered into PPP, like the international airports in Hyderabad and Mumbai under the Greenfield policy, and Mumbai and Delhi international airports under Brownfield policy. So like that, does we have any policies to this effect? So like this here, when you speak about this, it is a public-private PPP is a long-term contractual yet cooperative agreement between a public agency and a private sector entity with agreed to duties, risk, and rewards, in which both government and the private party have an interest. So in this case here, when you speak that both the parties, when they have entered, the share of a private investor is always high, the stake is always high, more than 76%, by which the risk is shared by the private person. So now you can go to the PPT number 1, 2, please. I request you to, because, you please stop there. Now, so I discussed about the research paper, what it explores, and what is public-private partnership, and why the government has preferred this public-private partnership, because it is budgetary constraint, number 1. Because whatever the budget the government is having, it has to cater the needs of various sectors, whether it is airports or space or railways or seaports, health, education, national highways, so on and so forth. So putting a high investment in one sector is nothing but the other sector will be losing a balance of economic development. For this reason here, due to the budgetary constraints, lengthy procedure in floating a project. If a government wants to float a project, today it has to float a tender, whether it is under the Central Vigilance Commission rules or if it is international, it has to go for the World Bank rules. So if on January 1st, if a tender is floated, January 1st, 2021, you can easily say that a contract, a PPP contract can be signed on January 1st, 2022, 1 year. In 1 year, there may be number of problems, taxes, labor laws, various type of problems will occur by which the price, the bidding price may go up. So instead of this, it is for the common good, it is for the public, by which the private person is taken into consideration. There is no need to go for a lot of lengthy procedure like floating a tender, by which the private person can go ahead directly and he can take note of top 10 personal companies and start with the project. So the private person has the capital. Why the government has preferred? Because the private person is having the capital, technical know-how, innovation, efficiency, managerial skills, accountability, transparency, etc. So delivering these services or infrastructure is in a timely manner is the mantra of a private person here when compared to the government, because government is laid up and fed up with what various types of procedures to be adopted in bringing out a project into limelight. So the government prefers to reduce upfront capital exposure because the private person is coming here. So it can save that type of capital and it can transfer that capital for another development or another sector's development. Now, why PPP in space sector is the next question for us. Because building modern, sustainable and reliable infrastructure is critical for meeting the rising aspirations of billions of people around the globe. Hence, this PPP could help to enhance the social benefits of the communication satellites. In our childhood, parents' childhood, my childhood, there's only one landline. But today, a family consisting of 5 members are having 5 smartphones. So it means what? The satellites are functioning. So it means there's a communication system going on between the persons. Today, internet, IoT is there, Internet of Things are there, artificial intelligence, robotics, blockchain technology, various type of technologies are there which are based purely upon these communication system or the satellites or those things which are sent in the orbit, functioning and operating in the space. So now the next point to be noted here is why, what includes the space infrastructure? Now my question is directly, when you speak about infrastructure, now in India we always go for the roads, laying of the highways. If the roads are good, then the transport system is good. And the goods will not be damaged, not be destroyed, and it reaches very safely. So it means it must reach, anything which is being sent must reach the destination safely. Under these circumstances here, the space infrastructure means and includes spacecraft hardware, software and components, system integration, spacecraft payload integration, space robotics, communications and Earth observation satellites that bridge low Earth orbit, geostationary orbit, and deep space orbits. Next, space exploration mission spacecraft. On-orbit satellite servicing vehicles. Today in our world-class airports, we are having MRO, maintenance, repair, and overhauling system. In the same way, here we must also have satellite servicing vehicles, robotics for ongoing space operations and exploration, spacecraft chambers, flight software labs, assembly and test area. So it means a huge land is required, it is to be acquired to go for a very good PPP project in relation to the space infrastructure. So under these circumstances here, when an international airport where a land of 5,500 acres is being used for a space infrastructure, it requires more than 25,000 acres of land, by which you can see the development of the space infrastructure in such a way that we will be one among the other countries. So PPP in space infrastructure, what are the key objectives? Number one is the mission support to advance science, space, exploration or national security and defense. And number two, functional support is required, such as a communication, observation or developing new technology. Then space industrial base, as today we are having special economic zones. In the same way, we must also have space industrial base to promote a competitive and robust commercial space sector. For now, however, the space sector is undergoing a rapid change, and it makes sense that the government, commercial sector, research and innovation, collaboration are becoming popular today. So the next question here is, why PPPs in space infrastructure is pursued by the government? Because we have stated that the government is seeking to expand their capabilities for satellite communications, navigation, earth monitoring, exploration systems, and other space applications. Recognize this is significant role that the private sector can play in delivering these capabilities at reduced cost and risk through public-private partnership. So these things can be catered only if it is meted out only where a private party enters with the government by way of a partnership. And efficiency gains, reduce life cycle costs, transfer the risk, innovation and technology alignment with space policy goals. All this can be pursued by the government by giving away the task to the private personality. So why private party pursues this public-private partnership here? Why private is interested? Because a high return on the investments, gain competitive advantage. So when you speak about the space activities at the global level, only 3 or 4 players are there. Airbus is there. Okay, at the same time, Lockheed is there, Boeing is there. These are the companies which are coming forward in relation to the space activities. So if you want to tap these type of personalities, because the techno-based personalities are available, and those persons technically, financially, okay, both must be brought into consideration so as to make the PPP a success at the Indian level. Now, when you speak about the mechanisms, I told you that various mechanisms are being operated at the international level under the PPP system. I gave you an example like BOOT, B-O-O-T, build, own, operate and transfer. At the same time, in the space sector, operations and maintenance is a type of mechanism being applied in relation to the PPP projects in the space activities. Operation, maintenance and management, that is OMM. In the same way here, if you take the US, the public-private partnership, they have used the mechanism that is a design, operate, build, finance and manage. So this is the type. So it means any type of mechanism which is feasible for the parties in a PPP, that is to be taken into consideration, but it is not at all, okay, we cannot say that it is 100% safe unless until you go for experiment. Later on we will be knowing, in spite of taking these type of operations and maintenance mechanism under the PPP for the development of the space activities at the international level by the US, they have failed. So those are the lessons which are to be learned. So what is the market forecast? All those things we will be discussing here. So when you take this particular lessons to be learned, one example I can give you where it is a strategized market assessment, forecast and business model concept. Actually, in this case, one company, NGA company, okay, there was a contract for 10 years in relation to the development of the space activities, And one of the clause which states that either of the party can terminate the contract at any time. Can you use that type of? So under these circumstances, the party has terminated the contract by which the whole project went into doldrums. So huge loss was sustained. Now the lesson learned in this particular NGA, Enhanced View program, was the government should conduct a comprehensive review of a commercial partner's business plan, including market forecast. If a private person is coming forward to the government must have a comprehensive review of the person. Today, when we are giving our daughter to a person marriage proposal, are we not checking everything? So we must also see that what is the status of the company, what is the background of the company. Okay, any losses have been sustained. So the government is having the authority, having a responsibility to go through all those things here. If not, before completion of the contract or before completion of the project here, it may lead to a disaster stage. So another example also I can give you, that is in relation to plan, leverage the seed money for the development of a private sector capability and select 2 or more partners to encourage the competition and hedge risk. Now in this one of the cases it happened where the government has invited 2 parties. So 2 parties, some seed money is given. Later on what happened here, other company has purchased this company to whom the seed money was given. So these type of things which happens, then what happens is the lesson which was learned by the government was the government used the PPP arrangements to essentially act as a venture capitalist. Early seed funding allows the project to grow. Once the project is operating well, the government can step back. So this is not the thing of a public-private partnership. If the government is backing off, if the government is withdrawing, so there is no meaning in relation to the agreement which they have signed coming within the ambit of the words of public-private partnership. Now, what are the key challenges here? Now, the challenges are the capital, including taxation, insurance and indemnification, liability, including quantum and possible sovereign guarantee issues. So, where there is a launch in relation to a spacecraft, accidentally it hits an aircraft in the mid-air, or it falls on so place where public dies. So who is responsible? So sovereign guarantee is there or not? Management of technical risk, regulatory certainty, including issues of authorization, establishment of continuing supervision mechanisms are to be, these are the various challenges here, and the safety and security of space assets and the dispute resolution mechanisms. These are the key challenges for us to go ahead. And what are the emerging legal issues? Do we have a regulatory mechanism? Professor Bhatt was right in saying that do we have a law today? So these type of activities, now when once they have announced that we are going for the private sector, the space sector is now open for the private sector. Where is the law? I am going to a shop without money and without a debit card. Can I purchase the goods? It is this thing which was happened very recently when the finance minister has stated that we are opening the doors for the private sector without a law. So it means regulatory mechanism not available to govern space-related PPP projects in India. This is the first one. Number 2, new models of privatization is to be explored. Why? Because at the Western level, European level, they have applied various types of mechanisms and they have burned their hands where we should not continue the same thing. And we have to see what is the viability in relation to the public-private partnership mechanism to be adopted by which we can have a fruitful project by which the citizens of a country can be satisfied. Then the modification in the digital law that is relating to the network development, regulations pertaining to applications, big data law, regulation and competition law in the digital market, security of networks and data. So when once you are bringing this PPP, other laws must also be restructured. They must be brought, some amendments must be carried on. Transportation law. So one of our foreign delegates, sir, was discussing about in relation to the aviation law. You are right, because when once the space shuttle is sent into the space, when once it returns, enters into the air, immediately the rules and regulations of the ICAO should be followed, even though it went into the space and it has entered. Why? Because the Chicago Convention 1944 speaks about the scheduled and non-scheduled aircraft by which it can be deemed as a non-scheduled aircraft by which it can be, the rules can be applied, like the certification, protection of the passengers, airworthiness certificate, so on and so forth. So there is no conflict here, because when once it entered into the air, till it is in the air law should be applied, because we are not having other types of laws. So the liability issues is also very, very important here. And if anything goes wrong, are our insurance companies ready to work for this? Are able to know, because they must go at the international level for the reinsurance of that particular area, space aircraft, if anything goes wrong. So reinsurance is a component by which they have to have a tie-up with international companies. If not, all the companies will collapse. So they must have a strong insurance background also, and the liabilities should also be curbed in such a way that they should not be, it should not lead to any disastrous position. Whatever the investment is there, it should not be more than the investment, the liability here. And finally, my conclusion here is regulatory mechanism is in the space activities in India is the need of the hour. So very importantly, at the root level today, we are thinking about tourism. Very good, you can go. But at the lower level, do we have the law? Do we have the, first of all, relating to space laws, except 4 treaties, the other, except 1 treaty, the 4 treaties we have signed, no doubt. But at the local level, municipal law, do we have? Are we comfortable with this? When you're not comfortable, first of all, at the ground level, we have to work out and bring out the legislations. Then we have to think of the public-private partnership in the space infrastructure activities. So policy protection to the investors. Are we giving any protection to the international investors? We say FDI, foreign direct investment. So what type of protection we are giving? So again, the norms are to be taken into consideration, brought into consideration specifically for the space. And greenfield, brownfield policy is the need of the hour. That type of thing we are not having except in the aviation sector. Restructuring of various laws like digital law, transportation law, etc. Liability issues pre-launch and post-launch. Dispute resolution mechanism. It means if the above factors which just I have discussed are taken into consideration, then we can say that there is a public-private partnership in the development of the space infrastructure in India, taking note of the international scenario. With this, I end. Thank you very much for giving me this opportunity to speak. I have given some information about the public-private partnership here. At the root level, the government has to think a lot, and if not, thinking about exploring something there, I hope there is no meaning at all in this case. So legal regime is to be first mantra to be developed here. Then only we can think about the explorations or exploitations or doing anything in the space. Thank you very much. Thank you one and all for giving me this opportunity.
Thank you, sir. Thank you for your insights. Next presentation will be by Dr. Rahul Nikam on IPR protection and Indian perspective in outer space. Sir, if you could please give a brief introduction about yourself and then continue with the presentation. Sir, you're muted.
Now, am I audible?
Yes, sir.
Okay, thank you so much. I think we are already delayed by 50 minutes, as per the given scheduled time. So definitely from my side, I'm going to stick to the 10 minutes. So, very brief overview I will be giving from my side on my presentation. I'm Dr. Rahul Nikam. I'm the Associate Professor in the Faculty of Law, Marwar University. And I'm so happy that, first of all, let me congratulate to the Sarfaraz Ahmed Khan, sir, Director SLS Hyderabad, for initiating this important topic, and also making sure that the young generation are also in the same line where we want a budding space lawyer, a kind of daredevil lawyers we want from our side, as if we want to conquer in the world as a developed country, then we must require this kind of daredevil sort of lawyers and advocates in the young generation. Also, congratulations to the Shailendra Kumar. I know him personally, so for his wonderful initiation, and also the distinct personalities who are present virtually in this Google platform. Now let's begin with the very quick topic. My topic is the IPR protection and the Indian perspective in outer space. So if we see right from the first session to the Balakrishna sir, who is my guru, who also spoke about here, then my another colleague Dr. Shafi, he also spoke, then my another colleague Dr. Sandeepa, he's also spoke a lot of things, and then my another colleague, that is Debashish. Dr. Debashish is also going to speak about the locomotive, the metaphor. He always prefers to identifies so many interesting things in the area of space and aviation. My only concern over here is that when we are having so many things happening in the edges of the Department of Space, followed by organization, one of the top-notch world-renowned organization, which we call as the Indian Space Research Organization. I can understand that right from the beginning. Let's say that when in the 1970s or 80s, when the Sarabhai was brought in, and then Kasturi Rangan, and then to the present all the leadership and our government efforts to realize the importance and accruing this benefit of the outer space application to the society at large. Now I think till this time the approach was like this, that since ISRO is the only leading organization and there is no private industry or any kind of industry support is there to the ISRO to develop the indigenous technology, so there was a necessity that it should be purely in the soft law in the form of policies, and then it is straight away coming under the Department of Space. So administratively also there were less hindrance as far as the hindrance otherwise would have been there if it is not been under any of the law. But now what I personally feel here is that now those particular regime is already over, and now from last 10-15 years ISRO has already put its effort, which has started realizing the spin-off benefits which is already there in terms of various space application, and also handing over various the machines and the softwares and so many things to the private industry for the betterment and in terms of commercialization also. Now here is the a dilemma. I will tell you very clearly how. If you do not have a special IPR law applicable and catered, especially looking into the specific generality as well as the specification in the nitty-gritty point of view for the outer space activity, you need to have a special legislation which is responding and addressing all those different type of treatment required for the IPR protection to the outer space activity. So now this is the the scenario. Now how to handle this scenario? There are two responses. One response is straight away you bring a special piece of legislation apart from the general intellectual property right law which is already prevailing in Indian context. You need to have a special intellectual property right protection, especially to the space activity. So name itself is telling you how the IPR law is going to look after all those application and commercial aspect as well as technology transfer emerging out of the space activity and space applications. The another way is if you do not have any specific law, then the general law will take care. So how the general law will take care? The general law is the Indian Contract Act, or you can say that a contract law in general. Suppose if there are two parties, let's say that the party who is the domestic private party and the ISRO, then automatically you are having two options whether you want to follow. By default they will be following the Indian contract law, and if not, then they will be curving out that particular agreement in a form where the Arbitration and Conciliation Negotiation Act 1996 will be brought into the picture. If it is not, and if suppose if there is the international foreign entity is involved with the ISRO, then obviously there will be the international agreement, and they will be again making sure that which particular rules regulation they are speaking in that particular agreement, international contract, that will be prevailing over there, and then the jurisdiction and the arbitration clauses will be taking care that if there is any dispute related to the IPR and the outer space activity, how they are going to be resolved. Now the scenario here is somehow one step ahead, and I will say 4 steps backs. How? I will give simple example. Till date, there is a soft law in terms of policy which has been given the direction to the ISRO to make sure that how the technology transfer and all those things are required there. We can understand that ISRO has put lot of efforts to develop the industry which can now start supporting technology and also the space application for the ISRO's various present and future projects. That I can understand and well appreciated. But now there is a need of however that when we see the present context, now the scenario is completely changed. ISRO must now come up with this particular policy that should have a backup of a specific legislation at hand. So in this regard, I will give you one simple example. Let's look at this NASA IPR. Now in the NASA IPR, you will find there are 5 type of these agreements are there which are exclusively talking about the IPR. And this particular IPR applications or technology transfer, whether it is for the NASA or on behalf of the NASA, either way it has been completely controlled by this particular 5 type of funded agreements. Now if you go through these, they are having a very specific legislation, and the name of the legislation is Space Act Agreement. And this Space Act Agreement is completely focusing on the technology transfer and IPR implications. So this particular agreement is focusing 5 areas, that is the rights in the patent and invention generated or used in performance of this particular agreements, data rights, publication of resulting data, handling of data, and release of the generated information to the public. Now if you see this one, this is the beauty, and this is what now we are requesting to our ISRO as well as Department of Space and Government of India, that at least if suppose there is a negotiation that is going on, so it is always the skill of the parties which they are applying in the negotiation and coming to a particular agreed term. There is a chance that the ISRO and the Department of Space may lose the benefit or their side of benefit which are required to be protected in terms of technology transfer. And also if it is been brought in that manner, then we are able to also make the secrecy and indigenousness remain with the ISRO and Department of Space. So if I give some clear example, so you can just say that there is a Space Act, the main act, and under this Space Main Act there is this another particular piece of legislation has been brought, and in this particular Space Act, especially section 305 subclause 8 talks about the IPR means and the Space Agreement, Space Act Agreement is other transaction. And then you will find there are certain important aspects, like let's see here I am highlighting this particular, that is the 35 USC section 200, and then if it is there is a waiver, then there is section 2457 subclause F, like that things are there. Now see this another thing also. Now here see the approach is also same what ISRO and Department of Space is trying to take here. They says that we will go as per the policy decision, agreed, but that policy decision and case to case basis decision has to be guided, and their genesis should be firmly acknowledged and controlled under the piece of legislation. So here I am talking that yes, there must be a legislation, but there should be one more specific legislation which should exclusively talking about the transfer technology and IPR related aspects. So if you see, if there is a patent, then there is this 37 CFR part 404 straight away comes into the picture, and then section 209 comes into the picture. Then again National Transport Technology Advancement Act is there, and here the section 3710 is again in the limelight. So same way for the right in the data, now handling of the data is also there. And then now coming to the India. Now if you see the India, latestly there is this policy which has been brought by the Department of Space. Now interestingly, this is, see the title, it is the policy and guideline. Now the question comes here that suppose if there is something goes wrong in the negotiation or the terminology or the interpretation of any particular clause of the particular this agreement, then obviously this particular policy and guideline will not be considered by court of law. They will simply say that what your agreement is saying, and as per your agreement, whatever the consensus ad idem and the intention and the interpretation that was expected by both the party at the time of entering into a contract will be prevailing. So the court of law will not even interested to go and look this particular technology transfer policy and guideline 2020. But instead of this, if the same policy, if they brought under the technology transfer and IPR related to the space activity in form of piece of legislation, then definitely the particular contract, the wording will be like this: whatever we have mentioned in this particular contract, it will be subject to the this transfer technology and IPR related activity to the Space Activity Act. Now here there is a utmost chance that even if suppose contract is saying something different, and if it's contradicting with the language of this piece of legislation, then definitely court of law will give preference to the piece of legislation and not to this particular contract, if you make the case in that manner. Now surprisingly, if you see here, I will straight away jump on. Now this space policy has said that there will be now another public sector company. Now I'm not able to understand, first of all, when you are already having Antrix Corporation Limited as the public limited company, as a commercial arm and as a deal breaking and deal space activity product supplier of the ISRO, then what is the necessary for the Department of Space and the Government of India to come out with the another particular company that is formed in the March 2019, and the name of the company is New Space India Limited. Now, okay, even for the minute we understand that, okay, what's harm in that? If you are having, instead of one, if you are having two companies in your hand, it will be a win-win position. But surprisingly, if you see the vision, mission and the mandate, they are more or less same. Then the question comes here is that now which particular company will be having a clear-cut scope and they're looking after the business and all the space activity related contract entering into with the another third party. So this is how one of the glaring example, and here it shows that it has completely messed up the present scenario, because now the question comes here is that suppose in the 10 years before there is a particular technology that has been transferred by the Antrix to the third party. Now that is also in existence, and now the present this particular New Space India Limited is also there, and now they are started also doing the same activity. So now here is the confusion, whether the Antrix is remain in the position in terms of its mandate and all those particular contract, because Antrix is the one of the party representing the ISRO. Now there will be another new party, and sometimes there is a chance also that the collusion will be there. Sometimes the Antrix and NSIL may have a similar sort of thing, but there will be only one third party who is entering into a contract with these two type of commercial wing of the ISRO. And if you go through with this, see, this is the major business area, again overlapping. So what I'm trying to tell here is that, see, we do not have any problem if you are not bringing out any kind of legislation, but at least for the sake of not messing up the things, you at least have such a kind of clear cut policies, or a clear cut sort of actions oriented your responses that are not at least messing up the present scenario. That is what the simple thing which I would like to brought to your notice. If any questions, those are welcome. Thank you so much. And now it is back to the Shailendra sir.
Thank you, sir, for your insights. The next presentation will be by Mr. Debasis Podar on substate actor as a locomotive for the outer space regime. Sir, if you could please give a brief introduction about yourself and then continue with the presentation.
Thank you, Akshara, for giving me opportunity. Am I audible?
Yes, sir. Yes, sir.
First, I sincerely offer my thanks to the event organizers, Professor Sarfaraj Ahmed Khan, especially for giving me this opportunity. Let me introduce, so far as my profile is concerned, I am at present working as Associate Professor and Dean of Xavier Law School in St. Xavier's University, Kolkata. Earlier, I have worked in two national law universities, Jodhpur and Ranchi, respectively. So far as my stake in international law, the air and space law, especially space law, is concerned, here I have honest confession that I am an alien. I do not belong to space law the way Dr. Sandeepa Bhatt or Rahul is PhD in space law itself. And I am really happy to see Dr. Sophie presenting a very comprehensive presentation. It is really a learning experience for me. But I have a stake in space law in the sense that I am a person of international law. I did my MPhil and PhD in international law. And from international law perspective, earlier also I have worked on space law, air law, etc. So I have, with this minimal stake, I will present my ideas on this particular area, which is basically looking at space law from international law perspective. So with this, I hope I have introduced myself and my stake in this subject. Now I am offering my small presentation. At first, I wish to introduce what I mean by substate actor. This needs explanation. So entire international law, the way it is running at present, international governance, here states are the main actor. So that is why international law sometimes I think it should be interstate law, because the concept of nation state is getting problematic and it is getting blurred with the concept of state. Now, what is nation, what is state? There are larger discourses in political science and other social studies. But here, essentially, I am not entering into that debate, but I am exploring the role of substate actors as a locomotive for the outer space regime, the way I have said my title. Now, states, besides states, I have identified that there are two types of actors. One is non-state actors, another is sub-state actors. Now, non-state actors, by and large, it is clear to general public that non-state actors are those who challenge state actors as another actor. They are actually contesting the international governance. Usually, the very popular non-state actor is the terrorist organizations, etc. But what is sub-state actors? By sub-state actors, I have found reference in several advanced literature, gesture articles, etc. So sub-state actors are those which are working under the umbrella of state, but with identity of its own. So I am giving you one example. Judiciary is a classic illustration of sub-state actors. Judiciary or the constitutional court, they are working under the umbrella of state, but at the same point of time, they have identity of their own by the judicial cloak of independence of judiciary. So even Indian constitution, in the Indian constitution also, judiciary, the judicial organ is not encompassed within the meaning of state under Article 12 of the Constitution, read with under Article 36 of the Constitution. So in that way, sub-state actor has a role to play in international regime. And space law, I am exploring the role of sub-state actors in space law. Now here, I am exploring, since the mandate of this conference is privatization of space law. So I am exploring the role of another sub-state actor in international space law regime, and that is the private commercial operators, multinational regime, multinational corporation, MNCs, or transnational corporations, TNCs. They are also sub-state actors in technical sense of the term, because they are working under the umbrella of state, but in several occasions we have found that they have left impression of their own. So there are cases in the before the International Court of Justice also, where state, the transnational corporations, etc., they have set their identity. So I remember Barcelona Traction case, where ICJ also dealt with this identity. So I am not going into the technicalities of Barcelona case in 1970. Last year, we observed the 50 years of that case, very important case in international jurisprudence. But here I am just, so far I have explained what is the sub-state actor and how I have identified the transnational corporations or multinational corporations here. Now, in the operative part, here I am exploring 2 points. One is that so far as sub-state actor is concerned, their role beyond the nation state, it is not new. So far as the expansionism of the Western states 200 years back in the name of colonization, there also we have seen that sub-state actors, they are in action. So far as Indian establishment under the colonial rule is concerned, it started with the East India Company. East India Company is purely a sub-state actor, transnational corporation, East India Company. So at later point of time, before British government took over in 1857, so almost 150 years, East India Company, they have expanded the British presence in India. So in that way, in international legal history, role of sub-state actor is clear, there is precedent. So if we extend it to this new space regime, so it is not something very untoward or unprecedented. So this is one point. Second point is that now at present across the world, we are the state actors, they are following the neoliberalism as a mantra of governance, that state will wither away slowly, state will restrict itself to essential functions like defense, like policing, etc. Across the world, it is followed that all the social sector or the private sector operators will take over everywhere except defense or policing, etc., which are essentially sovereign function of the state. So here I am extending an argument that what is the problem if we allow privatization the way usually in public international law there is an apprehension, widespread apprehension that if we allow at this point of time the private sector operators to expand their horizon in the new space or in the celestial bodies, moon or other celestial bodies, in that case actually will defeat the purpose of common heritage of mankind, will actually allowing them for private colonization, in our space colonization by private operators. So I find that I am a little skeptic about this. Here I am extending an argument that though East India Company actually felt the British presence in India, but at later point of time in appropriate circumstance, British government took over. So here is the point, my second and final point, that if we allow privatization of space activities, in that case, we are not defeating common heritage of mankind, because common heritage of mankind principle may be applied differently at later point of time. It is actually not defeat of common heritage of mankind. Rather, first we need to explore the new space or outer space celestial bodies. Thereafter, the question of control will come. At that point of time, state can easily assert their presence. So in that way, I advocated private rights for the time being in a restricted with reasonable restrictions. I advocated for private property rights in outer space. Thank you.
Thank you, sir. The next presentation will be by Rajrishi Ramaswamy on space mining and ownership, analyzing jurisprudential and legal perspectives with special reference to India. Rajrishi, if you could briefly give an introduction about yourself and then continue with the presentation.
Yeah, hello, good afternoon. Am I audible?
Yes, you're audible.
Okay. So a very good afternoon to the judges, to the director of Symbiosis Law School, Hyderabad, Professor Dr. Sarfraz Ahmed Khan, to the members of the Center of Aerospace Law, Symbiosis Law School, Hyderabad, and to all the esteemed presenters in today's international seminar. I am Raj Rishi Ramaswamy, a second-year law student at Symbiosis Law School, Hyderabad, and today I am here to present my paper entitled Space Mining and Ownership, Analyzing Jurisprudential and Legal Perspectives with Special Reference to India. Now, what is space mining? In very layman's terms, space mining is simply the process of extracting resources from a surface that is in outer space. That is, it could belong to an asteroid or a comet or even the moon. Why and how is space mining relevant in today's world? Over the years, as technological advancements have increased and more inventions took place and innovation increased, space mining, which used to be something of an element, fictional element used by sci-fi movie makers or sci-fi novelists to grasp their audience mind, has now inched closer to reality. In this regard, it is important for us to chalk out the legal position of space mining so that to ensure that future complexities or conflicts are minimized. Another aspect that we need to take into consideration is that private sector has also shown a lot of interest in involving in space mining. Now, as the previous speaker, sir, said, private sector involvement in space industry is becoming inevitable. In that regard, companies such as Elon Musk's SpaceX has also showed interest towards space exploration, space mining, and also space habitation. So we also need to regulate these companies. Recently, NASA authorized 4 of its private companies to go to space, mine resources, and return to Earth and transfer the ownership of those resources to NASA itself. Luxembourg made a law regulating space mining, and Russia seeks to cooperate with Luxembourg and make a new law for its own space mining ventures. China, in late 2020, sent a robo into space to ascertain whether space mining is a feasible option along with robotics. Even India had recently, in 2018, expressed its interest to mine or to extract helium-3 from the surface of the moon, which it plans to use as a fuel source for its space transportation systems. Now, in my paper, I have dealt with the jurisprudential perspective of space mining and ownership. Why have I incorporated the jurisprudential angle into my paper? I have done this on the basis of the jurist Salmon's view that a jurisprudential study of any aspect or any law tends to have repercussions in political, social, and legal aspects. He also says that a legal position can be understood better when studied from a jurisprudential angle. So when it comes to ownership and space resources, we need to take into consideration what the Magna Carta, we need to first look at the essentials of the ownership. Now in my paper, I have enlisted three definitions given by Austin, Salmon and Hilbert. A reading of these three definitions would lead us to derive that as ownership has a few essentials such as indefinite usage, right to dispose, right to exhaust, and right to destroy. Now, all these rights are available exclusively to the owner and not to other people. So, when it comes to space resources, we need to take into account what the Magna Carta of Space Law says. This is the Outer Space Treaty. The Outer Space Treaty, through Article 2, states that national appropriation of national or sovereign appropriation of space is not allowed, nor its use is allowed. And it further through article and also through article 1 states that there needs to be cooperation between member states in the use of space. Use in this context can also mean space mining. Now this raises the question of private space mining, since public state space mining is anyways prohibited by the OST. Now, as I've said, USA was able to send 4 of its companies to space to mine resources. How was it able to do so? Countries like the USA and Luxembourg first rely on what is called the maritime principle. This principle states that you cannot own the sea, but you can own its fishes. These countries are saying that we cannot own space, but we can own their resources. This argument is fundamentally flawed because of the vast amount of differences that exist between sea resources and space resources. Another thing that these countries are doing is misinterpreting the OST, or rather, conveniently interpreting the OST. They are saying that the OST does not expressly prohibit private space mining, while they are conveniently forgetting that the OST also does not grant access to private space resource ownership. Another thing that these countries are doing is conferring rights upon private individual or private companies through legislations. An example of this is the United States Commercial Space Competitiveness Act of 2015. What this act does is gives right to private individuals and private companies to go to space, mine space resources, and gives them ownership of the space resources they have mined. This goes against the very principle of the OST. Now, as per the jurist Gray, a right is something which has legal recognition. Seeing that the right given by these legislations go against the very international space principles, space law principles, these rights cannot be said to have legal recognition. Therefore, they are invalid. Overall, the jurisprudential principle tells us that perspective tells us that private ownership of space resources is not valid. This now brings us to the legal perspective. The Moon Agreement. Now, the OST has certain ambiguities which countries such as the USA are using to their advantage. But the Moon Agreement has provisions that are clear-cut in nature. The Moon Agreement, through Article 11 of Clause 3, says that no person, no individual person or government or commercial entity can own space or its resources. That is, they cannot claim ownership. Now, this prohibition is actually obsolete in an age where all involved stakeholders, such as governmental or non-governmental, are seeking to own space resources. That is perhaps the reason why Moon Agreement is not signed by a lot of countries. Just a mere 18 countries have signed the Moon Agreement. So, till recently, the position was as such. The OST had a lot of ambiguities, which was negatively exploited. The Moon Agreement had prohibitions which were obsolete in nature, and therefore there were insufficient regulations. This situation saw change with the adoption of the Artemis Accords in 2020, in October 2020 by NASA. The Artemis Accords basically removed the ambiguities in the OST as well as the prohibitions in the Moon Agreement. But are they the perfect solution? Not exactly. Countries, major space players such as Russia or China, have condemned the Accords and have said that it is too US centric. Now, I will get back to this issue in a minute. Coming to Indian space law. Indian space law is largely unregulated. There have been only about 2 major policies, one dealing with satellite communication and the other one dealing with remote data sensing. The closest India came to public-private partnership in space industry was the Space Activities Bill of 2017, which unfortunately had also lapsed, leaving Indian space sector, Indian space law with largely unregulatory elements, but with still a little bit of improvement here and there. These are the conclusion and suggestions that I have made in my paper based on the points I have described to you so far. First, the Artemis Accord should be of a global nature and not US centric. For this very purpose, the space arms of the United Nations, such as UN COPUOS or UN USA, can interfere and mediate and ensure negotiation between all the member parties, member countries, member nations, to ensure that modifications are made to the Artemis Accords or a new legislative framework itself is adopted. Now, the Artemis Accords do not penalize any breach made by any of its countries. This situation needs to be altered if space law regulation, if space mining or space ownership, space resource ownership regulation needs to be strict. So, for this very purpose, the Artemis Accords have to be modified in such a manner, or the new legislation needs to be in such a manner that there are penalizing provisions for those countries breaching the provisions. To countries like India and Brazil, a framework at a global level, such a framework at a global level will be of high significance for it to regulate its domestic private sector companies and to ensure that its public-private relation, public-private cooperation is in a very good manner and needs no further regulation. The jurisprudentially speaking, complete freedom or complete ownership as per the definition cannot be extended to private companies. However, the area under which they can operate, the freedom under which they can operate can be expanded. Finally, one thing which is to be remembered in case even if a new framework is being made or modifications are being made to the accord is that human greed has had deleterious effects on Earth for long, and this has been seen by all of us. The same should not happen with that of space or its resources. This needs to be kept in mind while dealing with regulating the space mining and ownership of space resources. Thank you.
Okay, these were all the presentations that we had for session 3. And now we shall move on to the question and answer session. So if anyone has any questions, you may put them in the chat box or you may ask them directly.
Kushi, you're not audible.
You're muted, Kushi.
I apologize. We've received a question which says, will the activities of the Asteroid Mining Corporation cause an asteroid to hit the Earth? Panelists, you may answer this question.
Could you repeat the question one more time?
Yes, sir. Sure, sir. Will the activities of the Asteroid Mining Corporation cause an asteroid to hit the Earth?
I think no, it will not, but we cannot also rule out whether they are having any kind of significant effect in generating new kind of asteroid and then changing their direction and straight away hitting to the Earth or nearby Earth. Because if you see the overall structure of the outer space, that the gravity is very zero and the things moves on their own speed and their own directions. So there is a 50-50 chance that, suppose if the space mining, this company is doing something, and if because of that, if it resulted into changing of the one or other, asteroid directions, then that will be a problem. But most of the time, I think there are, sophisticated technology through which, they can simply change the direction of the asteroid who are directly hitting to the, Earth or, Earth atmosphere. Like, the maneuvering of the, technology sort of thing. So they, generally maneuver, or they, through the propulsion push up, they simply, change the direction. So it can simply, just it can pass, just nearby side, but it will be not directly hit to the Earth or Earth atmosphere, like that. So technologies are already there, and if you have seen that there, these robotic arms are also there. So suppose if this maneuvering thing is not working out through the technology, then they can simply use the mechanic robotic arm, through which also they can, try to make sure that if any kind of small or big asteroid is hitting towards the atmosphere or the Earth, it can be, diverted from its directions and will not hit to the atmosphere or the Earth.
Thank you for that insightful information, sir. Now we have Miss Anushka Mishra, who is the who is a member of the advisory board to Center for Aerospace Laws. She's going to announce the awards for this ceremony. Anushka, are you here?
Khushi, if Anushka is not there, you can announce, and then then we can proceed.
Yes, sir. The best presenters for today's event are CH Amrita Gulshan, who topic contemporary issues in the traditional concepts of responsibility and liability in the age of space commercialization, and Rajrishi Ramaswamy, who has spoken on space mining and ownership, analyzing the jurisprudential and legal perspectives with special reference to India. Kudos to both the participants who have been awarded the Best Presenter Award. Now we shall proceed to the vote of thanks, which shall be given by Director Sarfaraz Ahmed Khan, sir.
Okay, thank you. We started in the morning. Now we comes to almost end of our program, and it's a great day. And definitely, it's one of the most important programs organized by your center. So, Center for Aerospace Laws of Symbiosis LawSchool, Hyderabad. At these occasions, I'm really one person's without whose support we could not have organized these programs, at least at this level, was my good friend Sandeep Bhatt. So thanks a lot, Sandeep, for providing all support to us and making these programs a grand success. It is his idea that okay, we can make it international programs. It is his support through which we have connected to so many people, including Dr. Thomas, who is present today. So I am really indeed grateful to him also, and to all the resource persons who came from the different part of the world who make the presentations, our Indian professors, Dr. Sheikh Nazim Ahmad, registrar, then Balakista Reddy sir, registrar Nalsar, Mr. Hamza Hamid. So everyone, every other persons, everyone who contributed, Rahul Nigam is present now. So everyone, I'm really from Symbiosis LawSchool, Hyderabad, I'm grateful to all of you. Believe me, this is not going to end, like conference might end. The vision of this conference which we have, that we are coming out with, we want some improvement in the literature, we want edited book publications, we want more activities in the centers of Symbiosis LawSchool, Hyderabad. So we will be in touch with you. We need your constant support. We need your advice, your guidance, and in all this process, this is one of the mechanisms by which it's helps in the learning process of our students. So we don't want our law school should be restricted to only classroom teaching. Like this, we have many activities which basically help in inculcating knowledge, skills among the students. So I'm really grateful to all the members. It will be unfair if I don't thank my colleague Salinder Kumar, who is in charge of this center, and from the beginning he was the person who was connected us with the two other organizations with whom we partner for today's program. In fact, we have an MOU with Law Mantra and International Council of Jurists, and these programs conducted under that MOU. So Salinder was instrumental in having that MOU. This also shows that we are very flexible. If as soon as the questions comes of having an academic engagement, we are always flexible to have more and more partners, and so that it can give an opportunity for us to have more programs on campus. We wish once next similar programs, maybe next year, we would like to do on campus physically, but this time virtually we have done, or might be in dual mode where many people from other parts of the globe, they can join virtually, and we all people from the India or some nearing countries who can come physically, who can join. So we can have other grand programs in the next year. I'm really grateful to all the members of Center for Aerospace Law. They have worked tirelessly from last few months, and every time who has submitted the paper, what is the deadline, sending reminder for the complete papers. Still many of them will be behind most of the professors who have not submitted their papers, or might be in the first review, second review, third review stage. So I'm really grateful to all the members of Center for Aerospace Law for making these programs successful. Your effort was instrumental in making the programs to this grand level successful. So I thank you all, and I have nothing to add, but it's really, it will not be one day affair. Program may be over today, but I believe Center for Aerospace Law must take lead in any academic activities on aerospace law in India. Our presence should be there. So with these few words, I thanks everyone. I do request Sandeep also to say few words at this concluding as a concluding remark of this conference.
Yeah, thank you, Sarfraz. I don't have anything to add on to that actually, except saying that actually it has been very well organized conference and thought provoking. And I was sitting through the conference this morning. And I should thank all my friends actually who have accepted my invitation, especially from abroad. Those resource persons who have actually participated, they have given a wonderful insight into what has to be done in terms of the privatization. I should thank all of them. And at the same point of time, I should also thank Symbiosis Hyderabad and your leadership for taking this forward, and also actually making this as a successful conference. I hope that actually, as Sarfraz has rightly pointed out, it should not be the end of it. I'm also continuing with the other endeavors. Next stop is 27th of February. I have already messaged, actually texted in the chat box. We are having a conference in NUJS in the similar lines. Already, actually, there are 10 resource persons from abroad who have already confirmed, and we will be having actually another mega event in terms of the International Space Law Conference. I welcome you all, and thank you so much.
With that, I think we've come to a conclusion of today's event. I thank everyone who's been a part of this event, and especially all the members of Center for Aerospace Laws who have been there throughout the event and the behind the scenes as well, with their immeasurable contribution to this event. And I thank everyone for being here.
Thank you everyone. Yeah.
Thank you very much. I would like to thank you very much for participation, for invitation. We have in Poland winter right now, so due to coronavirus, is a positive one fact that even now we can have such conference. So it simplifies from the logistic point of view that today, although I am at home, I am at conference in India. So it's one of the positive fact of coronavirus. So thank you very much, and I wish to meet you in real, let's say, real environment, and hope to have contact, and we will be in touch. Thank you very much.
Professors, before you leave, it would be a great help if you could leave a feedback for the event in the chat box here.
Okay, thank you. Yes.